ever stop to think about how our constitutional rights, these big promises, actually get defined day to day? How the Supreme Court interprets them over time?
Yeah, it's this constantly evolving thing, isn't it? And it really shapes everything.
Totally. And today, we're doing a deep dive into a really pivotal case that shows just that. District of Columbia v. Heller.
Right. Our goal here is basically to give you a shortcut to understanding Heller. We'll unpack the main arguments, look at these, well, very different takes on a fundamental right, and think about what it all means in the real world.
You should come away with a much clearer picture of this pretty complex decision.
Definitely.
So let's set the scene. This wasn't just lawyers arguing abstract points. It was, a real clash. You had Dick Heller, this D.C. special police officer, and he wanted to keep a handgun at home for self-defense. But D.C. had, incredibly restrictive gun laws back then.
Some of the strictest in the country, yeah. We're talking a complete ban on having a handgun in your house.
Right, a total ban. And even for other guns, like rifles or shotguns, they had to be kept unloaded and either taken apart or locked up with a trigger lock.
Which, makes them pretty hard to use quickly if you need to.
Exactly. So Heller challenged these laws, and boom, you've got this direct showdown over what the Second Amendment actually means.
And that really is the core question, isn't it? Just what does the right of the people to keep and bear arms mean? Simple words, but wow, the interpretations.
Worlds apart. You had the majority opinion written by Justice Scalia, and their main conclusion, the big takeaway, was the Second Amendment protects an individual's right to have a gun.
Right, unconnected to being in a militia.
Unconnected. And specifically for lawful purposes, like self-defense, especially you stressed, in your own home.
And how they got there is really interesting. It was all about digging into the text, word by word, almost.
Yeah, they split the amendment into two parts. You've got the first bit, the prefatory clause.
A well-regulated militia being necessary to the security of a free state. That part sets the stage, kind of.
Right. Exactly. And then the second part, the operative clause, which is the actual right. The right of the people to keep and bear arms shall not be infringed.
And the majority basically said, look, that first part states a purpose, okay, but it doesn't limit the second part. The second part grants the right.
And this next point was huge, focusing on the people.
Yeah, Scalia really hammered this. He said, everywhere else in the Constitution, First Amendment, 4th, 9th, 10th, when it says the people, it means individuals, all individuals.
Not some collective group like a militia.
Exactly. So why would it mean something different only in the Second Amendment? That was his argument. It has to be consistent, an individual right.
It makes sense from that textual perspective.
Yeah.
And then they looked at the specific words, keep and bear.
Right. Keep arms, they said. Pretty straightforwardly means to have weapons. They even brought up historical examples like Blackstone writing about rules preventing Catholics from, quote, keeping arms in their houses.
Okay, so keep means possess. What about bear arms? That one seems more debated.
It is. The majority argued it just means to carry weapons, for offense or defense. They pushed back hard against the idea that it only means military service.
Didn't they cite another case, even one involving Justice Ginsburg?
Yeah, Muscarello. They pointed out that even Ginsburg had interpreted bear a firearm in that case to just mean carrying it, not necessarily in a military context. They argued it only implies military service if it specifically says something like bear arms against.
So the text itself, they argued, points to an individual right for self-defense, but they didn't stop there, did they? They looked at history, too.
Oh, definitely. They found confirmation in early state constitutions. Pennsylvania's 1776 Declaration of Rights, for example, explicitly said, the people have a right to bear arms for the defense of themselves and the state.
Themselves, explicitly.
Explicitly. And they looked at the drafting history of the Second Amendment, proposals that mention individual rights, and what legal scholars wrote right after ratification. People like St. George Tucker, William Rawle, Joseph Story, they all seem to understand it as an individual right.
And there was that post-Civil War context, too, right? Protecting freed slaves.
Crucial point. After the Civil War, ensuring newly freed slaves could keep and bear arms for their own defense against violence and disarmament attempts was a major concern. There are government reports, like from the Freedmen's Bureau in 1866, saying that banning black men from having guns violated their constitutional rights.
So, text, history, and then they had to deal with United States v. Miller, the 1939 case. How did they handle that precedent? Because that was often seen as supporting the militia view.
They essentially reinterpreted it. They said Miller didn't actually limit the right to only militia members. Instead, it limited the type of weapon protected.
Oh, okay.
It protected weapons in common use by the militia back then, which the Heller court sort of updated to mean weapons in common use for lawful purposes today. So Miller was about the what, not the who.
Okay. That's a pretty comprehensive case from the majority. But there was strong dissent, led by Justice Stevens, and Justice Breyer built on that. How did they see it differently?
Fundamentally differently. They started right back at that prefatory clause. A well-regulated militia. For them, that wasn't just context. It was the entire point.
The single-minded purpose, they called it.
Exactly. They argued you can't just treat it like extra words, mere surplusage. It defines the scope of the right that follows.
So, for them, keep and bear arms had to be read through that militia lens.
Precisely. They saw it as a unitary right, meaning the whole phrase relates to military service, serving as a soldier, doing military duty. They noted the Second Amendment doesn't say for the defense of themselves, unlike some of those state versions.
So they argued maybe that broader right was considered and rejected?
That was part of their interpretation of the drafting history, yeah. They pointed to Madison's early drafts, and they leaned heavily on Miller.
How so?
They argued that for, 70 years, hundreds of judges had understood Miller to mean the Second Amendment protected arms only for military purposes. They really emphasized stare decisis respect for precedent.
They felt the majority was just tossing out decades of accepted legal understanding.
Pretty much. And their historical view was different, too. They looked at history and saw lots of firearms regulation, arguing the Second Amendment wasn't historically seen as this major barrier to gun control that the majority was making it out to be.
Okay, so two very different reads of the same words in history. But even the majority, having found this individual right, said it wasn't absolute right.
Oh, absolutely not. That's a really critical point Scalia made sure to include. He said this decision doesn't mean you can keep any weapon whatsoever in any manner whatsoever and for whatever purpose.
So what kinds of limits did they say were okay?
They gave examples of what they called long-standing prohibitions that are presumably constitutional. Things like bans on concealed carry, keeping guns away from felons or the mentally ill, laws forbidding guns in sensitive places like schools or government buildings, and rules about how guns are sold commercially.
And they stuck with that Miller idea about the type of weapon.
They did, but framed it for today. The right only applies to weapons in common use at the time for lawful purposes, and not weapons that are dangerous and unusual.
Okay. But the dissent, especially Justice Breyer, pushed back on the idea that history only supported an unlimited individual right, even in the home. He found historical restrictions.
Yeah, Breyer did some digging. He pointed out that even back in the founding era, there were local laws that restricted firearms for public safety, especially in cities.
Like what?
Well, like a 1783 law in Boston that said you couldn't keep a loaded gun in your house because of fire risk. The fine was 10 pounds, quite a bit back then.
Wow. So not exactly promoting having a loaded gun ready for defense.
Right. And there were laws in Philadelphia and New York banning firing guns within city limits. And gunpowder storage laws were common.
Gunpowder storage.
Yeah, laws requiring you to store gunpowder separately, maybe upstairs or even in a public magazine. Breyer's point was these laws, even if focused on fire safety or noise, did practically interfere with having a loaded firearm immediately ready for self-defense in the home. So the idea of limitations wasn't totally alien to the founders.
That's a really interesting counter-narrative based on local history. So, okay, we have these two big interpretations, the limits. How did this actually play out for Dick Heller and the D.C. laws he was challenging, the handgun ban and the trigger lock rule?
This is where the rubber meets the road. The majority struck down the total ban on handguns. Flat out unconstitutional.
Why specifically handguns?
Because, they said, handguns are the weapon overwhelmingly chosen by American society for self-defense, especially in the home, which they called the place where the need for defense is most acute. Banning the most popular self-defense weapon in the place you most need it. Unconstitutional.
And the trigger lock rule.
Same logic. The requirement to keep guns disassembled or trigger-locked, as applied to self-defense in the home, was also unconstitutional because it made the firearms inoperable.
It made it impossible to actually use the gun for that core lawful purpose of self-defense they identified.
Exactly. Now, the licensing part of D.C.'s law, they didn't really rule on that because Heller himself had conceded that licensing was okay as long as it wasn't used arbitrarily to deny rights.
Okay, so the core provisions were struck down. But Justice Breyer, in his dissent, defended those D.C. laws. What was the city's reasoning for putting them in place back in the 70s?
Right. Breyer wanted to show the court what the D.C. Council was thinking. He brought up their findings from 1976. They were looking at, quote, startling statistics about gun violence nationwide.
Like what kind of numbers?
Around 25,000 gun deaths a year, 200,000 injuries, and accidental deaths 3,000 a year, with a quarter of victims being kids under 14.
Grim statistics.
Very. And they had this specific finding that really jumped out. For every intruder stopped by a homeowner with a firearm, there are 4 gun-related accidents within the home.
Wow. 4 accidents for every defensive use.
That was their finding, and they focused heavily on handguns. In D.C., in 1974, handguns were used in over half the murders. They also cited data suggesting a crime with a pistol was 7 times more likely to kill someone.
So the council saw handguns as a uniquely urban problem, with little legitimate use there.
That was their conclusion, yeah. A policy decision, Breyer called it, tailored to D.C.'s specific urban environment.
And did Breyer bring in any more recent data to support this?
He did. Data from the mid-90s showed the problem wasn't going away. Over 36,000 gun deaths annually, hundreds of thousands of injuries. Handguns were still dominant in homicides and crime. He stressed how much worse gun violence rates were in cities compared to rural areas.
But he did acknowledge the arguments from Heller's side, right? The stats about crime rates may be going up after the ban, or the defensive gun use estimates.
Oh yeah, he laid those out fairly. Arguments that DC's crime rates didn't actually improve, comparisons to Europe, the estimates of millions of defensive gun uses, the idea that bans hurt good people, not criminals. He presented that side.
But he ultimately didn't find those arguments convincing enough to override the legislature's decision.
Exactly. His argument boiled down to judicial deference. He said, look, these are policy arguments, debatable statistics. They don't, quote, destroy judicial confidence in the D.C. Council's judgment about what was needed for public safety there.
So he favored an interest-balancing approach.
Yes. He wanted to weigh the burden the law placed on the Second Amendment right, which he saw as primarily militia-related anyway, against the government's really strong interest in preventing death and injury.
And he felt the D.C. law was a reasonable balance.
He did. He argued it was tailored to D.C.'s specific life-threatening problems. He acknowledged handguns are useful for self-defense, but said those same features make them particularly dangerous. He didn't see a clear, less restrictive alternative for D.C. to achieve its safety goals.
And fundamentally, he disagreed that self-defense with a loaded handgun at home was the main point of the Second Amendment.
Right. He saw it as, at best, a subsidiary interest compared to the militia focus he believed the framers intended. It really highlights that deep philosophical split.
Which brings us to the bigger picture, these clashing judicial philosophies. The majority, Scalia, very skeptical of judges doing that kind of interest balancing for rights written right into the Constitution.
Yeah, their view, often called originalism, is that the meaning and scope of a right are fixed when the people adopted them. Judges shouldn't be weighing whether a right is useful today or balancing it against policy goals. That balancing act, they argued, was already done by the people when they ratified the amendment. The right is the right.
Like the First Amendment, you don't balance free speech against its potential harms in every case.
That was the analogy Scalia used. The Second Amendment, he said, is the product of that balance already.
But Breyer strongly disagreed. He thought interest balancing is exactly what judges need to do, especially with complex modern issues.
Right. He argued courts have to weigh competing interests, especially when you have constitutional rights potentially clashing with public safety. And he felt judges should give deference to legislatures, the elected officials, on these kinds of factual, empirical questions.
Because the world today is just so different from the 1790s.
Precisely. No easy historical analogs for assault weapons or the scale of urban gun violence. So Breyer argued you need a more flexible, pragmatic approach.
And the dissenters were clearly worried about the consequences of the majority's ruling. Stevens predicted a dramatic upheaval.
Yeah, he foresaw judges getting much more involved in making vitally important national policy decisions about guns, something he felt was better left to legislatures.
And Breyer worried about practicalities, endless lawsuits challenging gun laws across the country.
Exactly. He feared it would encourage legal challenges everywhere, leave states unsure about what regulations were allowed, and tie the hands of officials trying to address gun violence through democratic means. And, well, we've certainly seen a lot of litigation since Heller.
No kidding. So recapping this whole deep dive, Heller really comes down to this fundamental split on the court. Is the Second Amendment's core about individual self-defense, or is it mainly about the militia?
That's the heart of it, and the majority came down firmly on the side of an individual right.
But, and this is key, they also said that right isn't unlimited. They left the door open for some regulations.
Right. But they left a lot of questions hanging. What exactly counts as a dangerous and unusual weapon today? How do courts apply that common use standard? How do you balance this individual right against public safety in specific cases moving forward?
Those are the questions courts are still wrestling with constantly.
Absolutely. And it just shows, doesn't it, that interpreting these foundational texts isn't static. It's this ongoing dialogue shaped by history, language, but also by today's realities.
Which leaves us with a final thought, maybe for you, the listener. As society keeps changing with new technologies, new challenges the framers couldn't possibly have foreseen, how do we think about balancing these fundamental individual rights against the need for collective safety?
It's a tough question, and Heller forces us to confront it. Where do we draw the lines now, and who gets to draw them? That's the ongoing debate.